our channel. I'm Matthew.
I'm Emmanuel.
And I'm Victor, black man.
Blackest who?
The blackest man in
Black
Africa.
Yeah, so back.
So, from where we left.
Yeah, this is a continuation of our last video.
Yeah. So, where we left, we didn't mention how the payment procedures go in the construction industry. So, right now, Kaiser is the developer.
Yes.
Sindio, you're the big boss.
Yes.
Then I'm the contractor.
Yep.
Sindio. So, if I want payment, I raise a claim. Sindio, I'll write a claim to Kaiser. Niaji, I need 500,000.
You write Niaji on your emails?
No.
And you're boss enough.
I'll write to Kaiser. Hello, developer. I need 500 G's for the works done for the past 28 days, let's say. Sindio. Then the developer, since he has a team, he has a consultant, the QS. The QS will tell the QS, go value those works.
Yeah.
So the QS will go value the works done and the materials on site, mostly. Then she will draft a
He or she.
he or she will draft interim payment certificate, which will state, yeah, this guy has been doing this, has this. Then share the same to the architect or the project manager to ascertain, okay, this is true, this is going on. Then after that, the interim payment certificate draft will be shared with the developer. Then the developer will authorize the payment.
Yeah.
Once he authorizes it, there will be other deductions, you know. There will be like in the 5%.
The retention fee.
There's a retention fee.
Yeah.
If there's something you've been doing, messing around, we deduct that.
Yeah.
All the deductions, but it should be stipulated that I'm deducting this. Then that interim payment certificate is issued. Now it is now official. Yeah, that's now after that is the whole process. Now, from what we discussed earlier, Kaiser, I raised a claim.
Yeah.
Then Kaiser says there are three options for Kaiser. Kaiser says, I won't pay you, or he fails to share how he will pay me, or he says he'll pay me, but a small amount. He says, from the way I look at you, my guy, only 50% I can pay. Yeah. So that leads to, what does that lead to, Kaiser?
It triggers in the application of the adjudication. Yeah. So in that case, if I don't agree with the amount I should pay him, or you raise the certificate with me and I don't respond to you, and the act is very clear on that, let's say where the other party fails to respond to the payment claim in accordance to section 5, clause 4, the initial party shall issue a notice of reference for the adjudication as though the schedule of pay less had been issued by the other party. So ideally, if I don't respond, you'll assume that I don't intend to pay, or you're not in agreement. So that's when you trigger the adjudication, and by that you'll now write a reference. You'll make a reference to the construction adjudication body to intervene in our case, and in that reference, as described in section 8 from clause 2, the reference includes, it provides the particulars of the party, it describes our positions, it also who is who, and it also identifies the payment claim which you raise to me and the schedule which I raised, say I'll pay you half, or I did not raise. Yeah, so once you write that to the adjudication body, it also should be accompanied by the fees paid that will be paid to the adjudication body, a brief description of the dispute, the remedy sought, a copy of the construction contract, a notice to refer for adjudication, and any other supporting documentation. So once you raise that, I'll also copy in and acknowledge it. Then the adjudication body will bring in an adjudicator to mediate or to adjudicate, actually, not mediate, sorry, to adjudicate our conflict.
Yeah. Also, in the same issue, we should note that when you raise a claim for any payment, this bill says that it will take 21 days. If within the 21 days, the developer or the contractor or someone who you supplied the material, he doesn't respond, that is when you can initiate this.
Yeah.
After 21 days.
Yeah.
Yeah. So, do you think it's fair? Do you think if maybe I being the contractor and you being the developer, if we had different times, if we had different agreements, a mutual understanding, we say that in maybe 5 days you should pay me. Do we change the contents of this?
If you agree, unless it's mutual, yes. But if you already trigger the clause of this, you know, when it says the 7, it means within 7 days.
Yeah.
You might have my debt and you tell me you'll pay me in 5 days, but under the bill, it's placed that within 7 days. So if you pay me within the 5 days, well and good, I'll be happy.
Yeah, doesn't change it.
If you don't, for 7 days,
you're going down, my G. Hey, itakuwa mbaya.
Yeah. Also, so within you raising the issue now with the adjudication body, the adjudication body should take 7 days to appoint an adjudicator to oversee the issue, to oversee the dispute. And one thing I like about this bill, you know, and its main purpose is to fast track these disputes.
Yeah.
That's why it's so big or keen on the timelines it provided for these actions, for the back and forth communications.
Yeah. So good thing is that I was just looking at the page I landed on. The adjudicator is actually defined.
Yeah.
Part of the preliminaries, that it's not just anyone.
Yeah, you should have one.
It's someone. It's an individual appointed, you know, by the construction adjudication body to adjudicate a reference to this particular part. So it's not just anyone, random person.
Actually, there's a council for adjudication.
Yeah, that's you're adding more to, you know, my point. That the council doesn't just
appoint anyone,
wake up and choose any John Doe.
Then another thing also, in the same council that appoints an adjudicator, I am very happy that there's a technical bench. They consult Borax. There's a member of Borax who sits in that adjudication council. Apart from the lawmakers, which there's a High Court judge, there's the Attorney General representative, there's also a member from Borax who will give a person who is knowledgeable in the field. People are requesting that if it can be better, the adjudicator have practiced for more than 30 years. Because now you will see many cases. If you are that seasoned, you'll give expert advice on matters of adjudication.
I think that's good, having a person with such deep experience in construction. I think to give him more context into the cases adjudicating over. That's a good move.
Now, sisi my youth.
Experience.
I have any experience in Abonga, eh?
Yeah, we are a work in progress.
We are a work in progress. That's true, especially. But I think in construction, the good thing is we always loop in the young folks. Yeah. In most times, if there's a senior guy who is doing something, maybe if you practice, let's say, green building. Yes. The construction is structured such that you can loop in a young folk. So I think that's okay. So we can go on with the adjudication process.
So now we've
initiated
the process.
Yeah.
So after we've initiated the process, now the adjudicator comes in, and for the adjudicator, as we said, once you write the reference letter, you attach some documents, ideally which gives context to the dispute, the contract, and the contract. So the adjudicator will also take his time. Ideally, it should be, let's see, how many days?
From what?
From once you submit the claim or the dispute. Yeah.
7 days.
Yeah, 14 days actually.
From
Section 12,
Section
clause 2.
12
class 2. 14 days after. Yeah.
Yeah, so on these 14 days, the adjudicator should go and look into the documents before coming up with a final decision. And one thing I like about this process, in that period of the 14 days, the adjudication is not really bound to the initial documents you submitted, which we discussed earlier on, such as the copy of the construction contract, the adjudication, the fees specified by the adjudication, the brief description of the dispute. But in that 14 days, the adjudicator can also conduct site visits to get more information on the dispute. The adjudicator can hold some conference calls by both parties. And also in those 14 days, if there's any new developing news or new piece of information that will add strength to the case or to any supporting party, you're also allowed to raise it to helping the adjudicator to make the decision. But in those, within the 14 days or when the 14 days elapses, the adjudicator should have made a final decision on the dispute.
So it's, in this process, the 14 days, he's gathering information through the conference calls, going to site, because he wants to be as
I think
fair,
it's less than 7 days.
Is it?
Yes.
In educators.
Like
we missed
here.
something.
Yeah.
No, you didn't miss anything. It says an adjudicator in 12, yeah? Adjudication,
Section 12,
yeah. Adjudication procedure. It says an adjudicator shall not determine a reference unless the response has been made or the period has elapsed.
Yeah.
An adjudicator shall determine a reference within 14 days after the date. Oh, yeah. After. I missed that after.
Actually, now you raise an important point where the adjudicator shall not determine reference unless the response has been made or the period of response specified under section 10 has elapsed. So section 10 says the referring party shall serve the reference under section 8.2 clause 2 upon the responding party and the adjudicator within 7 days from the date of receipt. So when the adjudicator starts receiving in the reference materials, he should not make a decision until that period has elapsed, meaning all parties that are in this dispute feel satisfied to have raised enough reference points or
Within
claims.
7 days.
Yeah.
So after you've been given a reference, yeah? For 7 days you'll be feeding the adjudicator with information regarding that dispute.
And the adjudication should not make a decision
During that period. Then after that period, after the 7 days, then the process starts, the adjudication bit starts.
Yes.
For 14 days, you debate, or
Yes.
what can we call it?
Adjudicate.
You adjudicate for 14 days.
In those 14 days, how I understand it is that if the adjudicator wants more information, it's the adjudicator who initiates contact with either of the parties to get more context or information on the dispute. It's not like during the 14 days one party comes to the adjudicator to strengthen their case or something. Yeah.
That's okay. Actually, I think from this document, it has compressed the time. Yeah, from other documents. Other documents usually states that adjudication might take 84 days. Yeah, but this one it seems like a month. Still, in less than a month, you guys should be done with this thing. Yeah, and also adjudication gives room for continuity of works during even your disputes. The works continue.
And the responses to the adjudication application under subsection 1 shall be in writing.
In writing, yeah. I think the first thing, construction managers are very important now in the construction industry, because the whole bill is about documentation. Without documentation, you can't do anything. You can't go forward with this bill.
So just almost anything in construction industry it has to be written. By written, have it in an email or even a WhatsApp text actually.
WhatsApp.
True.
Yeah, it counts.
Most projects are usually run on WhatsApp, and recently the code passed that you can use a WhatsApp text to formalize, to say like you can get into an agreement by WhatsApp. If I provide a WhatsApp text where we agree to do this job or this job under these terms, it's valid. So keep your documents safe, document everything, including WhatsApp serves as a legal document or reference point rather.
Before we go too far, just on WhatsApp, I was listening to a Nigerian lawyer describing, okay, maybe that's Nigerian law. I don't know if it applies in Kenya, but she was trying to explain. See, if you wanna bring some piece of evidence or record on WhatsApp, that was communicated through WhatsApp. And let's say it's a screenshot of a conversation, maybe between Emmanuel and Victor. So what she recommended was, before you share that screenshot, first go to contacts, delete the name or delete that if you've saved him as Emmanuel, delete the name Emmanuel. Just let it be +254 what.
Why?
Because Emmanuel can go and say, can go to court and say you just renamed someone else's name, like maybe it's my number, but you've just written there Emmanuel. So for it to be foolproof, because remember we're talking about being foolproof, delete the name, because once you don't have a contact in your contact list, it will just remain +254 what, which I don't think there are two people sharing Kais's number. So because up there where you ideally have the name, it will have the number, right? So that's just by the way, if you want to use your WhatsApp screenshots as evidence in a court of law, that's Nigeria. I don't know if it applies in Kenya, but why not?
You know, one of the subcontractors I work with, he has these one day messages. They just the time they just get lost. So he's a smart guy,
He has a timer.
He has a timer.
So if you tell him something,
messages,
it will disappear tomorrow the same time.
Then you'll be wise, delete the number and take the screenshots every now and then.
Okay.
You outsmart the smart.
So since we've known that WhatsApp can be used in the court of law, I think I'll have to be smarter this time. So we can go on to the adjudication decisions, page 9.
So
Page 9.
another interesting thing under section 12, clause 6. In that 14-day period, in case one party wants to add some information or submit further submissions to the adjudicator, so the right way is if I add some submission to be considered in that case, I need to notify the other party to agree or rather consent that it's not something false. So then the adjudicator might consider it in determining the dispute. So
during submissions of your documents, both parties should be present or both parties should be aware?
No, during the submission of during the submission period, which is typically 7 days, both parties can just submit freely. But in this, after that window closes, announce the 14 window period for the adjudicator to go through the document and make a decision. One party might come later on with another new piece of information. Now that new piece of information needs to go to the other party so that they can be in tandem, and then it's submitted now to the adjudicator for consideration.
I usually hear something like that in courts. I'm not a lawyer, I don't know, but I think I usually hear something like that when a new piece of evidence has emerged. Both sides need to.
What about the previous ones? Since now,
even the previous one.
The previous one during the 7 days. During the 7 days, do the evidence pass through the other? If I've initiated it, should the evidence pass through you?
So, yes, they'll pass through me for consideration if they're facts.
If they're facts, yeah. Nice. So that foolproofs the whole procedure.
Can someone take care of this, please?
Yeah. Engineer Jaredo will do it. So
I'm just, my glasses are reflecting a different color.
you notice now we
We
have changed.
Cut!
You should have put Tom and Jerry instead.
So adjudication of disputes from the same construction contract. An adjudicator may within
Where are you reading from?
13.
Okay, proceed.
We are all there.
Yes.
An adjudicator may, with the consent of all the parties to an adjudication application, determine more than one dispute arising under the same construction contract. That means that kama Mutero has been a crook all through since inception.
Yeah.
We've had issues with Mutero. We can submit all the things, all the disputes at that moment. Then we make one final verdict. The adjudicator makes one final verdict. But I think he should detail according to this issue.
According to this, yeah. I think you just have to separate them. You all agree that I also have this other issue. Can help us solve it. Yeah. And another interesting fact under section 14 is that the Evidence Act shall not apply to the determination of reference under this act. So, because the idea of this act is really to fast track things, it tries to remain as simple as possible. So, the interference of other acts or other regulations around are really minimized, or there's a formal way through which you can incorporate them to this act. Yeah.
To avoid conflict.
Yeah,
between.
Some people might use that act, the Evidence Act, to maybe postpone the verdict always.
True.
It's Cap 80.
The first definition of construction project. They say it's a capital intensive undertaking. So a person might say, okay, with other acts, let us just postpone this so that everything goes on.
The definition is the definite start time.
Yeah, with a definite
And end time.
Yeah, start and end. It's not infinite.
Yeah.
Yep.
So that's adjudication for you folks. I think the process is
We're kind of enjoying this.
yeah.
So
It's
on
like an educated book club.
So for the adjudicator part now, once the 14 days have elapsed and he or she has made a decision, he'll now proceed to issuing out with an adjudication certificate, which lays out the decision that has been made, that who owns who what, or who should pay
Who what?
Yeah.
What should be the way forward?
Yeah. So key things we can say that upon determination of the reference, the adjudicator shall make an adjudication decision specifying the amount to be paid, the currency in which the amount should be paid.
That is very important. Some people get messed up because of currency.
Currency.
Yes. And then the rate, the interest rates, and the date, the timeline by which you should pay the other party in that instance.
I would like to comment on the rate and type of interests, because
if any,
mostly there will be, since construction, from how I've seen it or how I've interacted with it, any delay in payment brings like a ripple effect in other things. If I delay in payment of my materials, that guy is incurring losses. My works now, my fundis even stop, So those damages that come with that, the adjudicator will also decide on how do we go about them. In simple contracts, there's usually this clause on damages. Is it liquidated and unliquidated damages? There's usually a clause on that, so this guy takes care of the same. Lisa, you can go.
And so that's it for the adjudication certificate. Is the final document for this adjudication process. However, it has a slight room for correction in case there's an error.
Because money is to error.
Money is to error. You can have even a numerical error. Instead of writing for me 500,000, you put in 5 million. So in case of such an error, you can go back to the adjudicator and they will correct on it. Yeah, so that's it for the adjudication process. But now the most important thing that we'll discuss next is the enforcement part of it, because most of this, you can discuss all this all day, still the adjudicator tells me to pay you, or through the adjudication certificate, I should pay you some amount and I refuse. So what happens to me?
What happens to you post the adjudication certificate?
Yes.
Yeah. So that's it for now, guys. Catch you in the next episode,
where we will discuss now the enforcement of the already issued adjudication certificate.
Yeah.
Stay tuned.
And goodbye.
Goodbye.